materials away from me and told me that the reason they did that was because they thought the materials would cause a disturbance. I'm here to present my case against that decision. Your first instinct might be to say that students are not granted the same constitutional rights as the rest of the population. However, the Supreme Court declared otherwise when they said, quote, "It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate," unquote. The official reason behind the school's decision was that there was a fear my materials would cause a disturbance. But the Supreme Court said, quote, "In our system, undifferentiated fear or apprehension of disturbance is not enough to overcome the right to freedom of expression. Any departure from absolute regimentation may cause trouble. Any variation from the majority's opinion may inspire fear. Any word spoken in class, in the lunchroom, or on the campus that deviates from the views of another person may start an argument or cause a disturbance. But our Constitution says we must take this risk," unquote. Furthermore, my plan did not involve instructional time at all. I had planned to pass out materials during lunch near the Tiger Den. As such, it does not constitute as action that, quote, "materially and substantially interferes with the operation of the school," unquote, and is therefore protected by the First Amendment. Upon further review of the Supreme Court's ruling, I discovered that WCS policy number 204 in its entirety is a violation of students' rights. The policy provides that all materials must be reviewed by the superintendent. The Supreme Court ruled against this type of policy when they said, "In our system, students may not be regarded as closed-circuit recipients of only that which the state chooses to communicate. They may not be confined to the expression of those sentiments that are officially approved," unquote. In another free speech case involving a high school, the court's opinion held that students' expression should not be restricted through any sort of authoritative selection. They also stated that students' rights, therefore, do not embrace merely the classroom hours. When he is in the cafeteria, he may express his opinions even on controversial subjects. The Supreme Court has always upheld free speech in schools as long as the actions of the students do not cause substantial interference or violate the rights of other students. My plan to pass out materials would not do either of these things, but would still turn into a matter of prior restraint and most objectionable form of censorship. The law, specifically the Equal Access Act, says that it shall be unlawful for the school to deny any student group equal access or fair opportunity to use the facilities and conduct activities. Because other groups were given a table and permission to pass out materials, the school must grant the WCHS Young Americans for Liberty a table and permission to distribute materials as well. The people have also expressed their support for my constitutional right to distribute materials. I've collected over 500 signatures of students and members of the community that are urging me to reverse the administration's decision and policy. So over 400 students and 100 adults in the community believe that the censorship in this case was a violation of the First Amendment right and the Equal Access Law. With the courts, the law, and the people on my side, I urge the board to do two things. First, reverse the decision of the administration and permit me and other students to distribute political materials during school hours as long as we do not cause an interference or violate the rights of the students. Second, I ask you to construct a policy specifically aimed towards students that permits the expression under the conditions previously mentioned, so that such policy stands in accordance to both the Equal Access Act and the Supreme Court's opinion on prior restraint. Thank you for your time. I ask the board to act swiftly because time is of utter importance. Please consider the opinion of the courts, the text of the law, and most importantly, the will of the people when you make your decision at the next board meeting. Thank you.